Justice Chauhan, Mr. Indra Kumar, and Arun, ladies and gentlemen. First of all, let me begin with an apology for my appearance, because my baggage was lost in the morning, so that is why I'm in the informal garb that I've come in. And second, the reason for me speaking here is probably my involvement with the Madras Bar Association cases, along with my senior, Mr. Datar, in the challenge to NCLT, the 2 rounds of NCLT, and the National Tax Tribunal. So I will just speak about those judgments and what Mr. Datar has followed this with a crusader spirit. Even he challenged the company law board itself when it was instituted in the Madras High Court. And since then, he has been at this judgment. And I mean, it was a great pleasure working on that case because, I mean, Mr. Datta's enthusiasm rubs off on us. And it was a long battle. Then it went from 2 judges. Then finally, a constitution bench heard it. And we did not get what we wanted, even though in all 3 judgments there was something that which spoke against the tribunalization of justice. But we did not get what we wanted. The closest we came to getting what we wanted was in the concurring judgment in Madras Bar Association versus Union of India, the NTT judgment, in the concurring judgment of Justice Nariman. So, anyway, the topic of this session is natural justice and procedural fairness. For the reasons mentioned by Justice Chauhan, I prefer to use the word which is more commonly used now, the duty to act fairly. So, I mean, it cannot be argued, and like Justice Chauhan said, the duty to act fairly can go beyond just judicial bodies. It goes to administrative bodies. It goes to all bodies exercising the power of the state. Let's put it like this. But the question when we are dealing with tribunals and natural justice is who enforces those principles. Now, most of the new acts have it that the tribunals are not bound by the Civil Procedure Code, but by the principles of natural justice. So there's a whole gamut of principles which will come in. Are tribunals necessary? Yes, without a doubt, they are necessary. But to what extent are we willing to give them the power to strike down legislation, to go beyond, and where is their jurisdiction lie? Now, after a long line of cases from Bharat Bank, J&K Iron and Steel, then Sampath Kumar, then Chandra Kumar, we came to Chandra Kumar, where finally the court held that a tribunal can be created which can supplement but cannot supplant. I have other problems with the judgment in Chandra Kumar because I think in some places there's internal contradictions within the judgment, because in other places they do say that Parliament can pass the power to strike down legislation to other bodies. But that was where it stood. It said that you cannot supplement the High Court. We were bothered mainly about the High Court's jurisdiction under 226 and 227 there. But in the NCLT challenge, the first NCLT challenge, we came across a situation where a High Court's power was being transplanted to a tribunal, which, as per our arguments, did not have the protections that the High Court had when exercising its judicial functions. So you are basically transferring judicial functions to a body which might not have the same protections which ensure that a High Court judge can fearlessly exercise his office. In the case of legislative power, the court had already held there can be excessive delegation of legislative power, but no categorical statement about excessive delegation of judicial power had come when it was done by Parliament. So that was our main aim, that the judicial power of the state cannot be given over to bodies which are not judicial in nature. That was the concentration of our arguments. So, but there is a distinction here. Are the principles of natural justice the same in all cases? No, they vary according to the cases. For example, if an administrative body is passing an order in personam against a single individual, yes, there is a part, the principles of natural justice will apply in this thing, that he should not, the procedural fairness, the principles of procedural fairness will need to apply. But if that same body is empowered, like the SEBI, if the Competition Commission, they also have powers to make rules and regulations. Now, if they are the body which is making subordinate legislation, are they under a duty to of procedural fairness? Can somebody come and say that I was not given notice of hearing, I am affected by these rules? It could be argued that if the rules are meant to single out a single individual or a single party, it could be violative of Article 14. But that is still the jurisdiction of the High Court. If the order or this thing or regulations, if the rules or regulations are violative of Article 14, it is still the High Court's jurisdiction to apply the law and strike down that rule or regulation. The tribunal's jurisdiction will only come into effect to see whether that authority or the regulator, which is at the bottom rung, has behaved with fairness, has applied the statute and the rules to the individual properly when it is exercising powers, in judicial powers, which is exercising in personam, not in rem. In rem would be orders or regulations which would apply to all. And this was held in Union of India versus Cyanamide Company in 1987 by Justice Chinnappa Reddy. It was a 3-judge bench. So now, from that background, we came to tribunals, and there were judgments we dug out from Mauritius, from Sri Lanka, the Privy Council, where they said that in one judgment, I think the power to grant bail was taken away from the courts, and the Privy Council struck it down. This is an essential judicial function. You cannot take away that power. So that was the background we were hoping for. The closest we came to was in the concurring judgment of Justice Nariman, when he said that there is something called the judicial power of the state, and Parliament cannot delegate that when it is exercised by the High Courts and the Supreme Court to tribunals which do not have the protection and which have to be exercised always by courts. It cannot be given to tribunals or any lesser authorities. So from that, we come to a system where we will at the bottom rung of the ladder stand the authorities and the regulators. From there, we go up to tribunals, High Court, Supreme Court. Now, the power of the Supreme Court under Article 136, you must see courts and tribunals are used 2 places in the Constitution. One is in Article 227, which, according to me, will go to the extent of superintendence over rules and regulations passed by tribunals. But till it reaches the tribunal stage, if a tribunal has been constituted, the power of superintendence of the High Courts is not there. So all the processes till this thing, notice in cases of tax cases, notices, orders passed till then will go to the tribunal. But if there is any other procedural fairness, it is for the high courts to entertain and to enforce. So that was our main argument. I think with the entity judgment, we were hoping that we had succeeded in a large extent in stopping tribunalization. But what is a minor setback is that in the second NCLT case, which came after that, the unanimous court has also struck down portions of it, portions of the NCLT, this thing. They said it must be complied with before you set up this NCLT body. The compliances have to be done. But in that case, even Justice Nariman concurred in that judgment, and he did not go as far as his judgment in the entity judgment went. So therefore, I think tribunalization is here to stay. We would prefer that it is there in a form in which the early judgments of the Supreme Court recognized, in Bharat Bank, in J&K Iron and Steel, that there would be superintendents, but they would be careful about interfering on merits with judgments of tribunals. And this thing, but I guess that's where we are at now. There are questions going to come about the powers. One I can think of is the National Green Tribunal. In every petition before the National Green Tribunal, there is usually a ground about Article 21. And the orders of the National Green Tribunal are very wide. They apply throughout the country against parties. Sometimes there's one judgment which came, I can give you an example, of the judges sitting in Chennai, the National Green Tribunal judges, who went into such detail as to say that a particular tree on the Girivalam path in Tiruvannamalai is the only tree to be cut in the widening of the road. So it is in such detail, and then, I mean, if you pass judgments from this at such distance without following, you send a fact-finding committee or whatever you want, but obviously there will be errors. There will be errors in application. There are errors in interpretation of what the court wanted. You know, it's like Chinese whispers. It goes from the order of the court to that district subdivisional magistrate who has to understand which tree is to be cut. I can quite imagine that he cuts the wrong tree, and then he'll be hauled up in contempt. And so this is how the tribunals are functioning, and there is reason to be scared. I think as regards the tax tribunals, they are the most successful. Historically also, from the income tax tribunal, they have been the most successful. And I think the subject matter is also attuned to tribunalization, if I can use the word. The other case which we had brought to the notice of the Supreme Court in this thing, and originally the Delhi High Court had struck down the Debt Recovery Tribunal. And in the context of what Justice Chauhan was saying about targets, there used to be a board outside the Debt Recovery Tribunal which said, you know, this is the recovery and this thing, the number of cases heard and recovery of amount, the amount of recovery. So, I mean, somebody brought us a photograph of it because we were representing the Madras Bar Association, showed us the photograph. So that was one of the things we mentioned, that if a tribunal function, and most of the debt recovery tribunals function in the rented premises of the banks, which itself gives it a, I mean, if it is, justice not being seen to be done, at least, if you want to apply the principles of natural justice there. But, so that was one example about this thing. And I still think it was finally, the Debt Recovery Tribunal was again reinstated by the Supreme Court. But after NCLT 1, the first NCLT judgment, in my opinion, the DRT is unconstitutional in the terms of its own of the order of the Supreme Court in that judgment. But after that, I don't think it has been challenged. So it is, so that's, yeah, that's my presentation about this thing. So I'll be happy to take questions afterwards. Thank you.